Hello and welcome to State Policies and Wholesale Power Markets. Our webinar today is with Troutman Sanders in partnership with Infocast Events. Today I have with me Stuart Kaplan, partner at Troutman Sanders. Before we get started on the webinar, Infocast would like to take a moment to inform you of our upcoming summit, Mid-Atlantic Power Market. At our summit, you'll be able to examine the shift in PJM's capacity market rules that are driving changes and creating new market paradigms. And you'll also be able to connect with industry thought leaders and decision makers, such as Stuart at Troutman Sanders today. And if you'd like more information or like to register, please head over to infocastinc.com/midatlantic-power. Again, that is infocastinc.com/midatlantic-power. And last thing, if you have any questions during our webinar, please type your questions in the Q&A box in the lower right-hand corner of your screen, and we'll make sure to answer questions if time permits. Thank you, and now I'd like to welcome Stuart Kaplan.
Thank you very much. Today we're going to cover the battleground between FERC and state policy. We're going to cover FERC versus state jurisdiction, so we're starting with the common foundation. Then we'll cover three types of preemption, but focus on two, conflict and field preemption. We'll then turn to a trilogy of Supreme Court cases governing the dividing line between FERC and state jurisdiction and authority, and then discuss the pending battles as the holdings of the Supreme Court are being litigated, some cases state by state, district court by district court, and so forth. These issues are affecting every sector of the marketplace. When states adopt programs to provide subsidies for electric generators or new innovative policies with respect to new market entrants, such as demand response providers, it creates new challenges for FERC, state regulators, and both state and federal courts to figure out. In practical commercial terms, it affects every sector because it affects what utilities that serve load must pay for power, including subsidies that may be adopted by states. It affects the generators that are receiving the subsidies, and it also affects the wholesale market prices when entry is hastened by or incentivized by subsidies, which can have the effect of suppressing or lowering wholesale market prices that those generators that are not receiving subsidies receive. So it can affect the valuation of existing assets. It can affect decisions about entry and exiting the market. It can affect load and what load must pay. It really is a field which has very profound effects, particularly in the ISO RTO clearing price markets. Let's go on to slide 5. The three recent Supreme Court decisions, which we'll get to, have addressed a variety of issues, and some of the progeny of those cases have addressed still additional issues. The boundary wars that the court has already addressed include whether state antitrust cases can proceed against natural gas companies where FERC is regulating related subject matter. That's the Learjet or One Oak case. Whether FERC regulation of demand response participation in the ISO market stepped on state PUC jurisdiction over the retail market. That's the EPSA case. And whether states may incentivize the development of new generation through state-administered competitive solicitations, resulting in a requirement that the utilities, the load-serving utilities, enter into CFDs, contracts for differences or financial heads, with the generators, and that's the Hughes case, which we'll get to. Go on to slide 6, please. Some of the pending cases that are in various stages of development focus on whether zero emissions credits offered in Illinois and New York as revenue sources for nuclear power plants are federally preempted as well. And additionally, in a speech that Secretary of Energy Perry gave in the end of April or beginning of May, spoke of whether state renewable portfolio standards might be preempted by the Department of Energy due to considerations of reliability and the need for baseload capacity and what the effects of RPS might be. And then finally, these cases also may implicate certain state programs regarding renewable portfolio standards and renewable energy credit pricing with respect to potential application of preemption. There will be other challenges, no doubt, and new innovative programs that will hit the interface between the states and their regulation of utility and energy markets, and FERC and its regulation of ISO RTO markets or bilateral wholesale markets. Go on to slide 7, please. So to start, it helps to have a common foundation just to make sure. Some of you are no doubt very familiar with electric market issues, and some of you are very familiar with natural gas market issues, and some both. But just to make sure we start with a common foundation, we'll run through FERC Jurisdiction 101 very quickly, and then move on to preemption. Under the Federal Power Act, FERC has jurisdiction over the sale of electric energy at wholesale. That means sales for resale, as opposed to sales to the end user. And those sales must be in interstate commerce. Now, for those of you who are familiar with the Commerce Clause, this is not a Commerce Clause analysis. It's a technical analysis, and anything that's on the interconnected interstate grid is in interstate commerce, at least once you get to the transmission level. So sales for resale on the interconnected grid, and that would exclude electrically isolated places such as parts of Texas, ERCOT, Hawaii, and Alaska, which are not interconnected on an interstate basis. FERC also has jurisdiction over transmission in interstate commerce, but we'll move on to slide 8. And under the Natural Gas Act, FERC has jurisdiction over certain sales for resale of natural gas. FERC also has jurisdiction over the transportation of natural gas in interstate commerce. So already you can see parallels between FERC's jurisdiction over electric energy and natural gas. But FERC does not have jurisdiction over other transportation of natural gas, which would be intrastate transportation or local distribution, traditionally provided by local distribution companies. FERC also lacks jurisdiction over production and or gathering. Move on to slide 9, please. So I think that it's helpful to look at FERC's jurisdiction and state jurisdiction by categorizing them as direct jurisdiction and indirect jurisdiction. In addition to having jurisdiction over sales for resale and transmission or interstate transportation, FERC also has jurisdiction or authority with respect to the rates, practices, and terms which affect such jurisdictional activities. Well, that is a very broad mandate. Things that affect wholesale markets or wholesale sales or transportation or transmission, it's very broad. Necessarily, there's implicit limitations on FERC's affecting jurisdiction. So FERC's direct jurisdiction under the Federal Power Act and Natural Gas Act are the actual wholesale sales and interstate transportations or transmissions. FERC's indirect jurisdiction under the acts cover any rule, regulation, practice, contract, or rate affecting those jurisdictional activities. Meanwhile, the Federal Power Act explicitly reserves for the states certain things because it says FERC does not have jurisdiction over them. And that would include local distribution, retail sales, electric generation on the Power Act side, and on the Natural Gas Act side, it would include production, gathering, distribution, or intrastate transportation. So these are things that I would call state direct jurisdiction under the Federal Power Act and Natural Gas Act because they're reserved for the states. They're part of what I would call a state savings clause. Now, states conceivably would regulate things that affect local distribution or retail sales as well. So there can be some overlap, which we'll get to in a moment. Let's move on to slide 10 and shift over to preemption. Preemption is based on the U.S. Constitution Supremacy Clause. Federal law is supreme. And there are three types of preemption. Express preemption is where federal legislation enacted by Congress explicitly preempts states from taking certain actions. That's not at play in these cases, so I'm going to skip over that. Field preemption applies when Congress and federal agencies acting within their statutory authority have occupied the field, leaving no room for the states to regulate. So FERC has direct jurisdiction over wholesale sales of electric energy or over interstate transportation of natural gas. And there's not much room for the states to act in those areas. In contrast, conflict preemption applies where FERC or the federal government does not fully occupy a field, and there is room for states to regulate in an overlapping field as long as the state regulation does not interfere with the federal regulation within the agency's statutory jurisdiction. So before we go on to the trilogy, and we can go on to the next slide, we have this dichotomy in the United States, which is different than many countries. Many countries principally have one national energy regulatory scheme, and they don't have state-by-state regulation or a system of federalism. And it means that we don't have one common energy policy. So it makes the application of jurisdiction and federal preemption somewhat unique to this country compared to many others. Moving on to the Supreme Court trilogy. The first case of the trilogy, One Oak, also known as Learjet, involved allegations that natural gas companies were manipulating the price of natural gas by manipulating price indices. Many sales of natural gas are indexed based on price indices. So if you can inflate the prices that the index publishers are posting, you can increase your profit on natural gas, theoretically. So in any event, FERC heard claims of manipulation and of improper disclosures and reporting to index publishers, and it investigated and adopted regulations concerning price index publishing and concerning reporting to index publishers. In two states, however, plaintiffs brought antitrust cases against the natural gas companies, alleging damages associated with their retail purchases of natural gas. And of course, in natural gas markets, you can have large industrial and commercial customers that buy gas directly from producers or from marketers, as opposed to buying from their local distribution companies. So the same indices can be used for both wholesale sales, subject to FERC jurisdiction, and retail sales, subject to state jurisdiction. In that case, initially, the district court granted the pipeline's motion for summary judgment, arguing that FERC was already regulating index publishing. You can go on to the next slide, please. FERC was already regulating index publishing, and as a result, the states were preempted from entertaining the antitrust cases. On appeal, the U.S. Court of Appeals for the Ninth Circuit reversed. It said there was no preemption because the state law claims were aimed at damages for excessive retail rates, not wholesale rates. It went up to the Supreme Court, and the Supreme Court affirmed in part. It found that FERC's regulation of gas index publishing affected both wholesale and retail electric rates, but it did not. But the antitrust cases did not constitute regulating wholesale rates for natural gas. FERC wasn't regulating wholesale rates for natural gas either. It was regulating a practice affecting wholesale rates. So this gets into that indirect jurisdiction I referred to earlier, the affecting jurisdiction. Meanwhile, the states were not regulating retail sales of gas per se. They were going after alleged, fraudulent or anti-competitive price disclosure information practices, but they weren't regulating sales. So it's something that affected retail sales. So the U.S. Supreme Court remanded to the lower court because neither the lower court nor the Ninth Circuit Court of Appeals had considered whether the state antitrust cases could peacefully coexist with FERC's regulation of gas index publishing. And it said you need to go back and analyze these under conflict preemption. Moving on to the next slide. On remand, the federal district court found that there was no conflict preemption and that the state antitrust suits would not interfere with FERC's effective regulation of gas index publishing. Now, I note in late Justice Scalia's dissent in the Supreme Court case, he noted that some companies would be subject to regulation in 50 different states and at FERC, and that once FERC occupied a field within its authority, it should be preempted so that companies would not be subject to potentially conflicting or inconsistent regulation. And it also foretold the potential for a lot of litigation. But that was in a dissent. And now we're going to be living with the effects of the trilogy, including one for some time to come. Let's move on to slide 14. So the second in the trilogy is EPSA. EPSA involved FERC regulation of demand response participation in the wholesale electric markets, in particular in the ISO RTO markets. Demand response, we have persons on this webinar from many different parts of the country, including bilateral markets as well as ISO RTO markets. And it is quite remarkable the extent of demand response participation in some of the organized markets. In 1 year in PJM alone, 12 gigawatts of demand response cleared the PJM base residual auction, annual capacity auction. And Joe Bowring, who will be speaking at that PJM, or rather Mid-Atlantic Summit that was discussed earlier, but Joe Bowring had estimated that in 1 year alone, the aggregate capacity market revenues were approximately $11 billion lower than they would have been that 1 year absent demand response participation. So it can be a very big thing in some markets. And EPSA involved a FERC regulation that required ISO RTOs to compensate demand response at full LMP prices when it participated in an economic demand response program. And on appeal to the DC Circuit, both with respect to the rate and with respect to jurisdiction, the DC Circuit, in a 2-1 split, found that demand response took place in the retail market, which the Federal Power Act reserved for the states. So it's, in essence, the DC Circuit said this is part of the state's direct jurisdiction and FERC should not have regulated. On appeal to the U.S. Supreme Court, the court reversed and found that regulation of demand response was not the regulation of retail rates for electricity or retail sales of electricity per se. And it also, I think that it's accurate to characterize this as not being related to, or not being directly a regulation of a sale for resale either. It was not a wholesale sale or a retail sale. It was not transmission. It was not distribution. But it was something that affected both. In any event, that wasn't part of the court's analysis per se, but it's an observation that I think is relevant, and I'll explain why in a moment. The Supreme Court then reversed because regulation of demand response was not that which was reserved for the states in the Federal Power Act. And FERC was free to regulate because it affected the wholesale market in a fairly direct way. So FERC could continue to regulate demand response participation in the ISO RTO markets. Now, unlike Learjet or ONEOK, this case was not a federal preemption case. There was no state policy that was being challenged as inconsistent with federal regulation. It was a straight up jurisdiction case. Who has jurisdiction? Does FERC have jurisdiction to regulate here? Let's move on to 15. The third of the trilogy involved programs. It really involved a program in Maryland, but there was also a parallel program in New Jersey. In New Jersey and Maryland, each state wanted to see electric generation built of a particular character in particular locations, and it found that there was not generation being built based on the market signals at that point. Both states, of course, were in PJM, still are, and each state adopted a program whereby the states ran competitive solicitations to see what type of contract for differences a new generator would need in order to agree to locate and build a generator in the specified location. And the states picked the winners and directed their distribution utilities, their integrated electric utilities, to enter into contracts for differences with the generators. In Maryland, it effectively established a hedge for the revenue the generator would receive from the PJM capacity and energy market. In New Jersey, it was capacity only. In any event, in both states, there were challenges by what I will call existing generation companies that were concerned about subsidized entry and the fact that it would suppress PJM prices, in particular PJM capacity prices. In both federal district courts, Maryland and New Jersey, the courts ruled that the state programs awarding contracts for differences were federally preempted because the states were crossing over in regulating the wholesale price, the price that the generators would receive for selling capacity and or energy in the market. The appeals went up to the Third Circuit from New Jersey and the Fourth Circuit from Maryland, and both U.S. courts of appeals affirmed the district court holdings. And then petitions for cert came by the generators that were going to receive the contracts for differences and the states that awarded them. And the court granted cert in the Maryland case and held that Maryland was effectively, it affirmed saying Maryland was effectively setting the price that the supplier would receive for wholesale capacity and energy. This is, and this was an area that was clearly preempted, an area where FERC had jurisdiction and authority. Now, you won't find in any of these decisions, either of these two district courts or either of the two courts of appeals or the one Supreme Court decision, you won't find them discussing in much detail indirect jurisdiction. The basis of jurisdiction is often not clarified, whether it's something that falls under the FERC affecting clause or something that is very directly related to FERC jurisdiction. But in this case, it was, in the court's views, a matter of the states setting the wholesale price of power, something that was directly related to FERC's jurisdiction and authority. Now, the Supreme Court decision tried to narrow its scope by stating that it was confined to its facts where the prices that the states were awarding the generators were tethered directly to the wholesale market price, where the generators had to clear the PJM capacity market to be eligible for the contract for differences, so that it was directly related to selling into a wholesale market. And the court was sensitive to say that there are other types of incentives for generators that states are free to award that are not tethered to the wholesale market and that don't have a requirement to sell into a wholesale market that would not have run afoul of preemption. Let's move on to slide 16. So, we've got jurisdiction. We've got jurisdiction that's reserved for the states, jurisdiction for FERC. We have two types of preemption, field preemption and conflict preemption. And we have the potential for state-by-state regulation, state-by-state litigation, like antitrust cases, and federal regulation that all have to interact with each other. And the holdings in these cases, especially the Learjet ONEOK holding, leave a lot to be determined in case-by-case litigation. So it is remindful, I'm sure some of you might have heard this joke, but it is remindful of the story about the doctor, the lawyer, and the engineer discussing who the first superior being on Earth was. And the doctor, of course, said, well, the doctor had to be the first superior being. Who else could create such a complex organ as the human body? At which point the engineer said, wait a minute, who was here first to construct the sun, the moon, the earth, the sea? At which point the lawyer said, but who was here first to create chaos? And what we've described here is a form of chaos, and one simple organizational tool is this simple grid, which looks at whether something falls under FERC's direct jurisdiction or indirect jurisdiction, the indirect jurisdiction being that affecting clause. Does it affect the wholesale sale as opposed to is it the wholesale sale? And then you've got the same, excuse me, the same two types of jurisdiction for states. Something that's state direct means that it's within the Federal Power Act's savings clause, where FERC cannot regulate, such as local distribution or retail sales. And then state indirect would be something that affects that, but is not that. So we've placed so far Hughes as a case that involved FERC's direct jurisdiction over wholesale sales and setting the rates for wholesale sales. Now, it also involves state direct jurisdiction in the sense that states are authorized to regulate siting of generation, certain incentives for generation, and that is within a state's direct jurisdiction. But in this case, the state stepped over that line and were regulating a wholesale rate, so it was found to be field preempted. Now, the Supreme Court does not spend any ink discussing field preemption versus conflict preemption, but the case I view as a field preemption case because the court explicitly declined to consider the conflict preemption arguments, which were the impacts on the wholesale market, as opposed to whether states were stepping on FERC's rate-making toes. In the lower right corner of the grid, you see FERC indirect jurisdiction and state indirect jurisdiction. Well, the Learjet case, it involved regulating the manner in which price formation occurred or price disclosure and index publishing occurred. So that's not regulating a wholesale sale or a retail sale, but it's something that affects both. So it was a double indirect case. And there it was found that conflict preemption applied. Now, EPSA was not a preemption case, it was a jurisdiction case. But we know that FERC is free to regulate demand response participation in the wholesale markets. So if a state were to adopt certain demand response provisions that interacted with the wholesale market, the state is not regulating retail sales per se, so it would be indirect. And what type of preemption would apply? Most likely conflict preemption, but that case has not been brought. Let's move on to slide 17. These cases have spawned progeny already. So also financial involved challenges to Connecticut's implementation of RPS and requirements or quasi-requirements to have utilities enter into contracts with certain types of renewable resources. In terms of the preemption challenge, there's an argument that the state was requiring utilities to enter into certain types of renewable contracts that were wholesale contracts and within certain rate establishing procedures or mechanisms, but that it was really a requirement that they enter into these contracts. The court rejected the claim. The district court and the U.S. Court of Appeals for the Second Circuit rejected the claim. The court first off found that as ultimately modified and as presented to the court, the Connecticut program did not compel the utilities to enter into these contracts. One of the terms of the program indicated the utilities were not required, that they could reject the proposals or bids. And additionally, there was no condition, as in the Hughes case, the Maryland CFD case, there was no condition that the generator had to sell capacity into an ISO New England auction. Although query, what would one do with capacity and energy in ISO New England? It probably would. But and finally, the contracts, I think the most other important points of the contracts that they were talking about here for the wholesale sales between the generator that was a QF, and these were not perfect QFs, incidentally. The larger ones were not. So that the contract would be a bilateral contract that would be filed with FERC and subject to FERC's review under Section 205 of the Federal Power Act. And on these bases, the court distinguished the case from the Hughes case and said that they were not preempted. Let's move on to 18. We also have challenges. The zero emissions credits were programs, or ZECs were programs in New York and Illinois to provide subsidies to nuclear power plants that were unable to recover their going forward costs from market revenues. The Illinois nukes in PJM and the New York nukes in New York ISO. So challenges were raised under both field and conflict preemption. And there were arguments about how tethered the ZECs were to the wholesale market or not. Let's move on to 19. In the Illinois District Court, applied Learjet and indicated that states are allowed to influence through regulation the generators that are in the market, and it found that there was not tethering between the ZEC and the price of capacity in the PJM market. Of course, programs that were crafted after the Hughes decision had additional guidance from the Supreme Court, so they can strive to try and avoid the pitfalls of preemption. To stop for a minute from discussing the law and say, well, what's going on commercially? And if you're looking to buy a generator that receives a subsidy, you want to know if that subsidy is good. If you own a generator that receives a subsidy, you want to know if that subsidy is good. And that reminds me that in the district court cases on the contracts for differences in Maryland and New Jersey, when the court ruled that the contracts of the state program in New Jersey, for example, was preempted, it voided the contracts for differences ab initio, which means back to inception, as if the contracts never existed. So if you're trying to do valuation on an asset that receives a subsidy and you're saying, wait a minute, not only might we lose the subsidy prospectively, but we could be in a big legal, pot of boiling water over whether we're going to get to keep the subsidies that previously were awarded. Now, if it's an asset sale, then maybe you don't have a retroactive refund issue with respect to the subsidy. But if it's an equity deal, then maybe you're taking over the project company means that you do have some retroactive exposure on the magnitude of the subsidy that was previously granted. So these issues can be extremely important on valuation to lots of parties, as well as important to the other generators that are looking to see what the capacity market prices will do. I mean, I was involved in one generator asset deal where the asset was pulled from the market as soon as it was announced that there was an agreement to retire a nuclear power plant, because the perceived capacity value of the plant would go up quite significantly based on a locational capacity zone. So these things do have lots of effects on lots of market participants. Okay, so in any event, the district court, I am running out of time here. I want time for questions and dialogue here. So the district court in both New York and in Illinois found that those two ZEC programs did not contain the tethering and did not contain the capacity clearing requirement that ran afoul in the Hughes case, and therefore they were not preempted. Let's move to 22, and on a simple 2x2 grid, we put the dissect cases in FERC's indirect jurisdiction and state direct jurisdiction. State direct because, again, states can regulate incentives for generators as long as it doesn't step on FERC's rate-making toes. Since the courts there found that there was not tethering and a capacity clear requirement, then they basically found that there was not preemption. They also found that the impacts on the wholesale market were not direct enough to create a conflict preemption problem. Both of those cases are on appeal to the U.S. Court of Appeals. So we will see appeals coming out of 2 circuits on that. And I don't think that the dialogue on those cases is over. I don't mean to suggest that they were correctly or incorrectly decided. That's not my place. And I don't have any jurisdiction over the district courts. But let me just shoot ahead then to slide 24 before we get into questions. There are parallel challenges when these cases have so many dollars at stake and so many market impacts at stake. You can expect there to be 3 parallel challenges. We just went through federal preemption challenge. These are federal court cases that are challenged initially in the federal district court. They go up to the U.S. Court of Appeals, and from there, if they make cert, they go up to the U.S. Supreme Court for a decision. In parallel with that, you have state law challenges because you've got a state agency that's adopting a program or a state legislature that's adopting a program. So through the normal agency or state legislative review process, you can appeal to state courts arguing that the state PUC did not act in a just and reasonable manner. The challenges can come from different places. I've been talking about challenges from generators that feel aggrieved by allegedly suppressed market prices as a result of uneconomic resources staying in the market. So the argument goes, and I don't mean to speak in favor or against it, that at the same time, you can have other renewable resources saying, why are you subsidizing those nuclear power plants when there are other zero emission sources that you're not allowing to participate in this program? For that matter, an efficient state-of-the-art CCGT might argue the same thing because they're displacing a coal unit or something. So there are challenges at the state level on a variety of grounds that have to work their way up through the state courts. And then the third area where you can have parallel litigation is before FERC, because FERC, as the guardian of the wholesale ISO RTO markets, is faced currently with a decision on whether to apply the minimum offer price rule in PJM or the New York buyer side mitigation rules to prevent a subsidized existing unit from bidding into the capacity market at a price that is below its going forward costs. If the going forward costs are above market clearing levels and they were required to bid into the capacity market at or above that price, they would not clear the market, and therefore they would not cause a reduction in capacity market clearing prices relative to the clearing prices if those units were removed from the market. And these challenges are currently pending. So with that, we can go on to slide 25. And this is sort of the adjunct to the joke that I told, which is, having been involved in 2 of the 3 appeals in the trilogy cases, I can tell you I would not wish this case-by-case uncertainty on any client. But since it's there, we'll gladly help you sort this out. So this is a good time to go to questions if there are any.
Thank you so much, Stuart, for your presentation. All right, let me take a look. We have a question here from Robert, and he asks, in Hughes, the Supreme Court found that MD and the generator had not entered into a bilateral contract because MD would not take title to the energy. If instead of CFD, MD had entered into a bilateral contract at an above market price, would the court have ruled differently?
Good question. The answer is maybe. I think that if the court perceived that the state was still effectively setting the price for wholesale power, and the state, for example, had coercion over the utility that was the off-taker under that contract, then it is quite conceivable that the court would still say the states are setting the wholesale price the generator will receive. So that issue remains to be ultimately resolved by the courts, but I think it will, that in some cases it may depend on those facts. But it certainly is one step closer to avoiding the Hughes pitfall. And presumably the contract, see, another aspect of that is that the contract might not necessarily be reviewed by FERC if it were under a wholesale market-based rate authorization. But if it were reviewed by FERC, I suspect that some of the protesters would raise the claim that this really is a function of state setting the price, and it would be in FERC's lap to decide. And FERC would have to weigh and balance issues. Because in the end, the courts are going to be interested in what FERC and the federal government's views are of whether something should be preempted or whether something should be deemed to be a state incursion on FERC jurisdiction. And how FERC handles that will depend on an entirely new commission, save Commissioner LaForte, but an otherwise entirely new commission that will be balancing conflicting interests between competitive markets and competitive forces on the one hand and respect for state action on the other. So it will take some time to see how that works out. Are there any other questions?
Yes. Ben asks, and I apologize if about the acronyms. I'm doing my best. If the Ohio legislator decides to move forward with ZENS or ZECs, how may it differ from the ZEN or ZEN results in Illinois? Would it have a more or less clear path to coming to fruition?
Okay. I hate to disappoint you, but I don't know enough about the particulars of the Ohio ZEC characteristics and the requirements to receive one. I can tell you that amongst the key factors that the court would consider would be, is there a requirement to clear an ISO RTO market as a capacity supplier and to offer energy into that market? Is there tethering to the wholesale market price? So for example, in the New York program, originally the staff paper had recommended that you calculate the going forward costs of a nuclear power plant. There were 3 nukes in question there. And then to offer a ZEC that would be the difference between the going forward costs and the wholesale market revenues the plant would receive from capacity and energy sales into the ISO market. Nothing could be more tethered than that. Now, the New York Commission did not adopt that program. It adopted one after Hughes came out that tried to differentiate itself from those pitfalls. So questions are going to focus on several factors, but one will be, what are the requirements to be in the market? And is that a meaningful distinction? That'll probably be argued on the appeal from Illinois and New York ZEC cases already. And then, is there tethering to the wholesale price? And those are amongst the key factors. Depending on the context also, are distribution utilities required to offer a contract or something like that would also be a relevant factor. Any other questions?
Thank you so much for that. We have a question from Michael, and he was wondering if we could possibly go back to slide 17 and if you could explain more about why CT and GA RECs are different. Would you like me to go back to that slide, or is that?
Sure. Yes, I'm going to go back to 17. The sorry, and the question was why CT and which ones? CT and
CT and GA. Oh, sorry.
Oh, okay. Yeah. It's I don't have a detailed explanation for you on why the court found that the Georgia ZECs were different, but and I don't know how meaningful the distinction was to begin with. So in this situation, if you're talking about ZECs that are creatures of state law and that are offered for resources that satisfy a particular state's requirements, then it is quite conceivable that the requirements would be different between the 2 states. This, by the way, was more relevant to the Dormant Commerce Clause challenge than to preemption. It was not relevant to preemption, but a Commerce Clause challenge is that a state regulation imposes an undue burden on interstate commerce. Now, interestingly, FERC was created back as a result of a litigation over one state's regulation of the wholesale rates from a sale by a generator in a different state. And it was held to violate the Commerce Clause by imposing burdens on interstate commerce, at which point there was a gap known as the Attleboro Gap, which prevented regulation of wholesale sales because state commissions couldn't do that, at which point FERC was created in 1935 to regulate wholesale sales of electric energy and transmission and interstate commerce, amongst other things. And I don't know if we have time, but if we have time, is there one more question you got?
Yes, there's one more. Let me just go back to the question section. So this is from Kay, and they ask, what are your views about FERC jurisdiction over small distributed energy generator sales to utilities as states move away from net metering pricing to market-based pricing for such sales from DG resources to utilities?
Okay, so with small distributed energy, I think that first off, if they're behind the meter, FERC has accepted in some of the ISO markets the concept that it would look at sales over the course of a month. So, if you have a behind the meter generator that never exceeds the retail load behind that meter, then theoretically that generator is never introducing energy onto the interstate system or making a wholesale sale. If you have some hours where the local load behind the meter is low and the generator output of the behind the meter resource exceeds the local load, then in that context, FERC is willing to look at these things on a billing cycle basis or a monthly basis. And if the net sales over the course of the month are in favor of purchases from the grid or from the utility onto that distribution system, then that would be deemed to be something that was not subject to FERC's jurisdiction, and FERC was content to allow that to be handled at the state level. However, if on that net metered basis you ended up with positive sales onto the grid, then the behind the meter generator, the seller of that power onto the grid, would need to do so under a FERC approved wholesale tariff of some sort, such as a market-based rate tariff. This is a finer point, and I will go over it quickly because I don't want you all to fall asleep if you're awake still. And that is that theoretically, you could make wholesale sales on a distribution system where the power flow from the grid is always onto the distribution system. Even though you've exceeded your behind the meter load, or you're not even behind the meter. But if that part of the distribution system, let's say it's a load pocket or an island, always has flows from the grid into the load pocket or onto the island, you're theoretically never making a sale in interstate commerce, even if you're making a wholesale sale from a resource on that grid. But I don't know if FERC would agree with that. I still believe that's the right analysis, and it's one that would likely engender a different view from some folks that are concerned about their jurisdiction. But we've just begun to see the evolution of the proliferation of behind the meter generation and microgrids and other new phenomena which are going to challenge regulatory constructs and jurisdiction going into the future. And just like many renewable resources at the beginning, they might not initially have a big impact on the wholesale markets, but going into the future, they very well may and are expected to have a much bigger impact.
Thank you so much to Stuart for your great answers. Thank you to our audience for these excellent questions. If you have any more questions for Stuart, please make sure to email him at stuart.kaplan@troutmansanders.com. I'm sure he'd be happy to answer your questions. And for our last slide, I just want to say thank you again to Stuart for an excellent webinar and to all of our attendees for tuning in. Just a last thing, as a reminder, you will receive an email with the recording of this webinar within 24 hours. So if you want to look back on anything, feel free to. And don't forget, make sure to sign up for our Mid-Atlantic Power Market Summit, which will be in Philadelphia in late October. And actually, Stuart will be there. So to further explore any related topics, Stuart will be a moderator for a panel at our summit. And so feel free to meet with him for any one-on-one meetings. And as Stuart told me, cocktails are welcome. So please make sure to say hello. And thank you again.
Thank you, Catherine. And I just want to also say thank you to Adrienne Thompson, associate of ours in our Portland office, who helped with the presentation and did a great job. So thank you.
Yeah, thank you to both. Make sure to register or learn more about our summit at infocastinc.com/midatlantic-power. That's infocastinc.com/midatlantic-power. Thanks again, and hope everyone has a great day.